Hello, everyone. Welcome to today's webinar. We'll be discussing trademark protection in China and Southeast Asia using WIPO's Madrid system. Thank you all for joining us. We'll start by giving the floor to Benoit Apercé, who is the Communications and Informations Manager at WIPO. So please, Benoit, the floor is yours.
Good morning, everyone. It's a real pleasure to welcome you in this first joint webinar with the European Commission IP SME Helpdesk. Our partnership is important because it brings together the global reach of the WIPO Madrid system to protect your trademark abroad with the Helpdesk practical business-focused support. So European SME, you can get both strategic guidance and advice when protecting your trademark internationally. Today's session is the first of a broader series of regional markets webinar. In the coming months, we will continue with new sessions, including one focusing on the WIPO Hague system for global design protection. ASEAN markets and China is also a key priority for us at WIPO. For this reason, we have just created a new role, a new ASEAN market specialist, led by my colleague Aileen, who will present today, so we can better respond to SME needs and questions on the ground. Finally, I would like to thank and acknowledge all the IP Helpdesk colleagues for the excellent cooperation and a special appreciation to the Southeast Asia IP SME Helpdesk team and in particular Giovanni. And now it's my pleasure to welcome and to pass the floor to Valérie Marie Davigno, our Policy Officer at DG Growth, European Commission. Thank you very much.
Thank you very much, Benoit. Good morning, everyone, and welcome to today's webinar. It's a pleasure to open this new series with Benoit. It's designed to help the European SMEs and entrepreneurs like you protect your brand as you expand into key global markets. Whether you're exploring opportunities in China, Southeast Asia, India, or Latin America, safeguarding your trademark and design is critical to your success. Why? Well, because your intellectual property isn't just a legal asset, it's the heart of your brand's identity and reputation too. Yet protecting it in unfamiliar markets can seem complex. That's why this series delivered by the World Intellectual Property and the International IP SME Helpdesk is here to simplify the process and give you the practical tools you need. Today, we are focusing on China and the ASEAN region, and you will learn how to navigate the trademark landscape in these fast-growing markets and key consideration for protecting your brand as you expand, and how the WIPO Madrid system can help you register trademark efficiently across multiple countries. This is the first series of webinars that will also cover India, Latin America, as well as other aspects like the WIPO international trademark and also design protection. So there is plenty more to come. I'd like to thank the International IP SME Helpdesk and the WIPO for putting this together, and all of you for joining us today. Now let's get started. Over to, I think, April Wei from the China IP Helpdesk to kick things off. Thank you very much.
Thank you. Thank you for your introduction. I should see my slides now. Yes. Good morning, everyone. I'm April from China IP SME Helpdesk. Today, we are going to look beyond the basics of trademark registration. We will focus on the specific traps that European SMEs often fall into when using the Madrid system to enter the Chinese market. By the end of this session, you will know exactly how to avoid losing your brand rights due to procedures techniques. First, the golden rule in China is the first to file. It doesn't matter if you have been selling your products in Europe for many years. If someone else registers your brands in China first, they own it. Let me give you a real-world example. It is about a Danish home design company. They had sold their designs globally for a decade but delayed filing in China. They thought their EU registration would be sufficient. When they finally entered the Chinese market, they found a local trader had already registered their exact brand name. What was the result? They were forced into a costly legal battle or had to rebrand entirely, losing years of marketing investment. With China having the highest trademark filing volumes in the world, speed and strategy are your best defenses against squatters. Waiting was not an option. Many of you consider the Madrid system for entering China. It is excellent for cost savings and central management. However, for China specifically, one size fits all doesn't work. There were three critical local details you must know: the subclass system, the certificate requirement, and the time frame. Ignoring any of these can turn your cost-saving strategy into a legal nightmare. Let's start from the first one. China uses the NIS classification but breaks it down further into subclasses. This is unique to China. For example, look at Class 25 clothing. In the international system, clothing is a broad term, but in China, Class 25 is split into over 10 subclasses, like 2501 for outerwear, 2502 for infant clothing, and 2507 for sports jerseys. These subclasses are often considered dissimilar. If your Madrid application uses a broad term like clothing without specifying these sub-items according to CHIPA's strict standards, you risk a partial refusal. The examiner may say your goods are not standard or simply reject the coverage for subclasses you didn't clearly claim. We see cases where a company protected shoes but forgot slippers, allowing a squatter to register a similar mark for slippers. This creates consumer confusion and dilutes your brand. This is the number one reason for delays in Madrid destinations in China. You must align your item list with CHIPA's database before filing. Do not rely on automatic translations. Rely on Chinese standard item list. Second is, let's talk about the enforcement. Once your Madrid registration is successful, WIPO sends you an international certificate in English or French. But in China, this document is often not enough. To take action against infringers, whether filing an applicant on Alibaba or Jingdong platform or suing in court, you generally need the official Chinese language registration certificate issued by CHIPA. Why? Because local enforcement bodies and e-commerce platforms operate in Chinese and require a local document to verify your rights quickly. The international certificate is valid, but practically it creates a barrier. This is a separate step. You must actively apply for it and pay an additional fee. If you skip this step, you may find yourself holding a valid right that you cannot enforce. Imagine winning a legal argument but unable to show the judge the correct piece of paper. It should be the risk. Now the most dangerous scenario comes, the provisional refusal. If CHIPA finds an issue with your Madrid application, they issue a provisional refusal. You typically have only 3 months to respond. The deadline is strict and rarely extended. But here is the hidden killer, the mandatory local agent rule. Under Chinese trademark law, Foreign applicants must appoint a licensed Chinese trademark agency to respond to refusals. You cannot do it yourself, and your European lawyer cannot file the response directly. Let's break down these 3 months disappear. At the first week, you will receive the notice. It is in Chinese. You spend time getting it translated. After that, you realize you need a local agent. You start searching, checking credentials, and negotiating fees. And later, you agree on a price. You need to sign a POA, power of attorney. If the negotiation is required, that takes more time. After then, the agent finally starts drafting the legal arguments. And luckily, maybe after 2 weeks or 1 week, the arguments is reviewed and finalized. It may cost 2 months. Suddenly, you are in the 3rd month. One delay, one holiday, one misunderstanding, the deadline passes. The trademark is died. No appeal, no second chance. Therefore, my suggestion is that do not wait for a rejection to find an agent. Since local representation is mandatory for your complex procedure, identify your local partner before you file. Speed is everything, especially in China. A quick but vital reminder. When you designate China via Madrid System, it covers mainland China only. It doesn't cover Hong Kong, Macau, or Taiwan. These are separate jurisdictions with their own IP offices. If you plan to sell there, you need separate applications. Do not assume one registration covers the whole region. This is a common misconception that leaves gaps in protection. Looking ahead, China is strengthening its laws. The upcoming trademark law amendment and China's stance in international negotiations show a clear trend. A crackdown on bad faith filings and a stronger emphasis on intent to use. This means owning a trademark without using it might soon become harder to defend. To help you navigate this, China IP SME Helpdesk offers free guidelines and fact sheets covering all these points. We also provide a free consultation service where you can ask specific questions about your case. And please do not hesitate to contact us. Thank you. Protecting your brand in China requires precision, not just intention. I hope these insights help you build a safer strategy. I'm happy to have your questions later. Thank you so much.
Thank you, April, for your very insightful and informative presentation. And now I would like to give the floor to Elio for his presentation. Elio, you have the floor. Thank you.
Thank you very much, Aileen. Happy to be here and to present on behalf of the Southeast Asia IPR SME Helpdesk. I will share my screen now. Okay, can you see my screen?
Yes.
Okay, great. So I will present the Madrid System through the lens of Southeast Asia. My name is Elio de Tullio. I am the founder and managing partner of de Tullio & Partners. We are an IP firm. We assist SMEs in protecting their IP rights in Southeast Asia and worldwide. The Southeast Asia IP SME Helpdesk is a European Commission initiative aimed at supporting SMEs in raising the awareness and protecting their intellectual property rights in Southeast Asia. I would say the quote is "know before you go." So the Southeast Asia IP SME Helpdesk provides free first-line confidential advice on IP, helps SMEs raising awareness about IP matters. They have a lot of tools for this purpose. So the inquiry helpline, a website, and the newsletter. It organizes workshops and live webinars like this, IP business tools, and publications. You can find everything on the IP SME Helpdesk website. You can also receive, upon request, a one-to-one consultation offered by experts identified by the Southeast Asia IP SME Helpdesk. The agenda of today is full of contents. We will speak first about risk assessment, then the trademark filing strategy, the probability of successful prosecution, and the steps required to prepare the enforcement. Some of the contents have been already anticipated by our Chinese colleague, and so I would be happy not to overlap, even though I will repeat some concepts because this is very useful in order to afford the Southeast Asian countries' markets. The Southeast Asia region comprises 10 countries, each operating under its own legal framework. So even though there were some efforts to harmonize the legal framework of these 10 countries, now a unified trademark system has not been yet established. So I would say the analysis and the strategic approach should be done on a jurisdiction by jurisdiction basis, since some differences are still in force. The Southeast Asia IP landscape has shifted from a very slow bureaucracy to a very high-speed digital environment. We have a lot of reforms, in particular in Indonesia and Vietnam. In Singapore, that remains the regional commercial hub. We have a very flexible legal standards. There are some other countries like Thailand, Indonesia that are a little bit more bureaucratic, and sometimes they apply rules in a very strict way. This is the membership of the Madrid System. As you can see, all Southeast Asian countries are member of the Madrid System, apart from Myanmar. In Myanmar, they are discussing about the, let's say, an evolution of their approach to the trademark system. So I think that there will be some news in the next years. So while the Madrid System simplifies the process, there are some critical issues that persist. For instance, each national trademark office will examine the application received under the Madrid System based on its local laws, and so what is accepted in a country cannot be accepted in another country. There must be some differences. Some countries, as mentioned before, apply extremely rigid examination standards that can, I would say, make the Madrid System less attractive, even though for SMEs, the Madrid System is always very much attractive due to the very good value for money value. The first step, of course, before affording any filing and any protection, even in Southeast Asian countries, is let's say, the validity search, the trademark search. So checking in database if identical or similar marks are already registered in the market of interest. Of course, the collection of data is important, but the important is also the availability of a legal opinion, so an assessment and interpretation of these data according to the relevant practice and jurisprudence. And also to receive, let's say, a feedback about the chances of success to overcome provisional refusals or possible interferences, but also about the free use and valid registrability of your trademark. There are some free database available on which you can check your the availability of your trademark independently, like the WIPO Global Brand Database or the TMView, and particularly for Southeast Asian countries, the ASEAN TMView. Generally speaking, if you decide to involve an IP expert, he or she can use also professional database to, let's say, to go a little bit more in depth about also what are the applicants, what are the possible competitors that can make your registration a little bit more complicated. As mentioned before, in Southeast Asian countries, like in China, there is a first to file doctrine. So in some countries of Southeast Asia, there is a first to file doctrine, in particular those countries that adopt a common law system. But there is a mix in Southeast Asia among countries that adopt common law systems and countries that adopt a civil law system. So let's say you should check before going to this market, exporting your products and services, what is the, let's say, the right approach, and in order to, let's say, be prepared for any kind of contingency. A general recommendation is that the first, the earlier the better. So if you file as soon as possible before entering the market, this is much better. So you can establish your rights, and also to try to extend the protection also with defensive trademarks in those classes that are not immediately of interest of your business. For Southeast Asian-based businesses expanding internationally, there is also the risk of dependency. So the 5-year dependency period provided for by the system, that is really a critical point. So if the basic mark is cancelled or successfully opposed within the first 5 years, the entire international registration collapses across all designated countries. And this is a problem in particular in the case of bad faith filings. So it makes your trademark vulnerable in these countries. But for EU-based companies, main risks are related to differences in languages, provisional refusals, registration certificate, and subclassification. The most common issue for foreign applicants is the high frequency of provisional refusal. So you must be prepared to receive provisional refusal, in particular in some countries like Thailand and Vietnam, but I would say also Singapore. Some of these countries like Thailand adopts a very rigid classification. So some products that are accepted according to WIPO, they are not accepted by the national office. And when you receive a provisional refusal, you need to be represented before the office, the local office, by a national IP attorney, and this makes things a little bit more complicated. So the best solution is to start the international filing involving an attorney in the country of origin. So if you are based in EU, EU IP attorney, so then he or she can liaise with the local attorneys and handle with these provisional refusals. While using the Madrid system, the trademark application must be filed in English, French, or Spanish, but usually local offices translate in the local country the list of goods and services into the national language for their own gazettes, and this makes some troubles because there could be some mistranslations risks in countries like Laos or Cambodia. Nuances can be lost in translation. Some products cannot be translated properly, and there are also some possible enforcement hurdles because in local courts, judges can rely on the local language version of the registration and not the original English version of the WIPO filing. So it is advisable to carefully check the translation before starting any enforcement action. Another problem can be the subclassification system. There are some countries that do not have a subclassification system, but other countries where they are heavily influenced by subclassification, like Indonesia, Thailand. So they are member of the NIS classification, but they adopt also subclassification. And in Vietnam in particular, It's the examination guidelines of the national office use a grouping logic for similarity that resembles a sub-classification system. So the office evaluates similarity based on whether goods serve the same purpose or are sold in the same channels. And this can involve some issues in the substantive examination. So these are the countries in which there is no subclassification: Singapore, Philippines, Laos, Cambodia, and Malaysia. So the subclassification sometimes can make the registration process longer than usual because the international registration can be refused due to non-conformity with the list of goods and services. So the Madrid system is always a good choice in terms of value for money. But if the identification of goods and services for which protection is sought is complicated, this can create some problems in the registration process. Differently, when the classification is very is easier and is brief, the Madrid route can be the best solution. While the Madrid system, and regarding the trademark filing strategy, while the Madrid system is designed to provide equivalent protection to national filing, there are some differences in speed. So if you have a heavy business going on in local countries, you can consider to file local applications. So in countries like Thailand and Indonesia, sometimes a national registration certificate is needed. Is a physical or formal digital document that local authorities recognize and e-commerce platforms recognize instantly. For a Madrid filing, you receive a statement of grant of protection, which some local administrative bodies may find less familiar. So in this case, you need to request a certified extract from the local office to prove your rights in courts or to have customs enforcement, and this can create additional problems. Regarding the substantive examination, the timeline for the registration of a trademark via the Madrid system is usually slower than a direct national application, because of course the application first goes to WIPO for formal examination, and then it takes 2-4 months before it's sent to the OCA offices. These are the standard timelines for some of the Southeast Asian countries. But once again, if your main goal is to save money, the Madrid route is the best one. Filing through the Madrid system can be a good first step, especially if you are looking for the best value for money solution. But you must be ready to face with provisional refusals. Indeed, responding to provisional refusals under the Madrid system needs strategy and organization. You need to, in case, translate the office action. You need to understand the contents of the office action, the legal grounds, and you must be ready to respond. Then in some countries, also there is an examination, substantive examination in connection with the relative grounds. So if the trademark is new or not, we will see this in the next slides. So in any case, in order to respond to office action, you need to involve local agents, and this can, of course, involve additional costs and sometimes lapse of protection in the countries of interest. As to the substantive examination, in almost all Southeast Asian countries, the trademark officers perform a substantive examination, in particular in Indonesia and Thailand, where this is very strict, but also in Vietnam, Singapore, Malaysia, and Philippines, officers do a substantive examination. And sometimes this substantive examination is also carried out on relative grounds. So if the trademark is new or not. And this, of course, can involve some, that fees, official fees have already been paid. So you face problems when you are already on the route and you are, okay, I would say in the middle of the route. So you need to so spending this additional money is mandatory. The way to predict how will be and to what extent your application will be successful or not is the availability search. So what I mentioned before. So check if your trademark is new or not, and perform a mitigation risk analysis in order to reduce possible additional costs. Also, the registration certificate is can be an issue. It's not always automatically issued and may require some specific formal steps. In particular, if you go for the Madrid system route, it will be issued a statement of grant of protection rather than a separate local physical paper, and this can create some problems. As to the timing to respond to an office section, usually in some countries is very strict. As you can see, in Indonesia, you have only 30 working days, and this timing can be extended only for force majeure. And in Thailand, the deadline cannot be extended. So you need to be ready and prepared to this eventual circumstance. Some analysts have calculated a currently estimated at 75–85% of a successful rate in case you perform a pre-filing clearance search, either under the WIPO global brand database or the ASEAN TMU database, and without a search, of course, the probability drops significantly due to the examination of national offices. In Singapore, there is more flexibility because sometimes the office accepts letters of consents from prior owners in case you have some interferences or some problems with prior owners. In contrast, Thailand has a lower success rate for overcoming phonetic objections because the office applies very strict practice. As to the steps in order to prepare enforcement actions, it's a kind of wrap-up of what we already mentioned in all the presentation. So, of course, one step is the acquisition of digital and certified proof of ownership. So the request of certified extract from local offices in order to be ready for the enforcement, in order to satisfy the requirements of local customs or specialized IP codes. The customs recordals is mandatory in some countries like Vietnam and Thailand. Then you have also you need to be ready to enroll your digital protection in e-commerce brand registries immediately upon receiving your statement of grant of protection if you use the Madrid system. And finally, for some jurisdiction, you also need to consider the lapse for no news because they are use it or lose it markets like Cambodia and Philippines. You need to demonstrate the use of your trademark. And so in order to avoid this risk, you need to collect all the evidences of the use in your records. Here you can find some publications where all this information are evidenced for your purposes. And thank you very much for your attention.
Elio, thank you so much for your very detailed and informative presentation. I can already see a lot of questions in our chat room. Later on, we will have a chance to answer some of the questions. And if we won't be able to, I think we won't be able to answer all of them, but we will make sure that we will answer them. Some will be through email because there's many, many questions, and we're so happy to receive your questions. Now it's my turn to present to you the Madrid system. Let me share my screen to you. Elio, can you see my screen?
Yes, yes, please.
Thank you so much. Let me just do this very quickly. Okay. So again, we've just heard how diverse and complex and sometimes unpredictable the trademark landscape can be across Southeast Asia and China. With April's presentation, that's really a lot of information about how we can get protection in China. There are different procedures, strict examination standards, and first to file risk that Elio has just mentioned. So the need for local agents when there are refusals, and even at the beginning of your trademark filing. And it's precisely because of this complexity that many SMEs, businesses, even multinational companies look for a way to simplify their trademark filing strategy when entering multiple markets at once. So in just a couple of minutes, we will be discussing about why protecting trademarks internationally is complex and how WIPO Madrid can simplify this process. And towards the end of my presentation, I'll be showing some of the eMadrid and other tools and resources that can help you in your practice. While expanding into markets like China and Southeast Asia, businesses are often facing a lot of challenges, as we have already heard earlier. And each country has its own forms, they have their own languages, different fees to pay, and different procedures. So managing across these multiple jurisdictions can become costly and resource heavy. And this is exactly the type of burden the Madrid system was designed to reduce. So the Madrid system was established in 1891 and it has proven its resilience over time. For over a century, it has been continuously tested, refined, and shaped by practice, making it even more relevant in today's modern and global business environment. It offers centralized filing system, as what we have heard earlier, that allows applicant to file one application in one language with one set of fees and one currency to secure protection across multi-jurisdictions while streamlining renewal, changes, and ongoing portfolio management after the trademark has been registered. So a single procedure through WIPO replaces multiple national filings across multiple markets, including China and nearly all Southeast Asian countries, which reduces duplication of work and administrative expenses. To illustrate this process, let me introduce you to our fictitious entrepreneur named Sally. Some of you might have seen Sally in the previous presentations from WIPO. So Sally runs a growing honey manufacturing business and is looking to expand into new markets such as Indonesia, Thailand, Vietnam, and China. If Sally files nationally, she needs to appoint 4 local representatives, prepare 4 sets of forms, translate her application into 4 languages, as we also heard earlier, pay fees in 4 different currencies, and later manage 4 separate registrations and renewals. But through Madrid, she files 1 international application and designates all 4 markets, no translation needed, no separate filings, and no separate renewal management. So how does the Madrid system works? This is just going to be a very high level presentation. So I will show you how Madrid system works in 3 steps. The first stage is the filing through your national or regional IP office, for instance, EU IPO. This is going to be your office of origin. Keep in mind, the Madrid system is a closed system, so you must have a connection through a nationality, a domicile, or establishment with a Madrid member country. The second stage is the formal examination by WIPO. So WIPO checks your application and it has to meet the formality requirements. And this is where all different tools and resources will be useful for you before even filing your application, or even before thinking about your pre-filing strategy. Substantive examination by each designated country. So that's going to be your first step. And this is the part that is really important. Each national office still applies its own laws and practices. This means Madrid System simplifies procedure through centralized filing, but it does not override national legal standards. On this slide, you can see a quick cost comparison of application through Madrid and through national route. For a trademark application covering 2 classes and designating countries such as Indonesia, Thailand, Vietnam, and China, the Madrid system provides a single consolidated fee, as what we can see here. If Sally used the national route, she would pay 4 different sets of official fees, 4 sets of translation, 4 local attorney fees at the very start of the application, not even at the refusal stage, if there is any. So the total cost is significantly higher. For this example clearly illustrates the Madrid system's advantage in cost efficiency when multiple countries are involved. At this juncture, I would like to emphasize the importance of thinking over and prepare your pre-filing strategy. And this is where WIPO and IP SME Helpdesk partnership can help you build a solid pre-filing strategy so you can fully benefit from the Madrid system's cost-saving benefit. On this slide, you can see the geographical coverage and those accession outlook of the Madrid system. So you can see that we are already covering almost all parts of the world. According to Madrid Yearly Review 2025, the Madrid members represent 68% of all countries globally, accounting for 82% of world's population and contributing around 90% of global gross domestic product. For businesses entering the Southeast Asia and China, this coverage means that a large proportion of their priority markets can be reached through a single filing. I will just put all this, the images together so that we can see the overall system of Madrid, how it works. So in this graph, you can see the life cycle of an international registration, from the filing formalities to national decisions, and then the long-term management activities like renewals and change in ownership and other things that can happen in the life cycle of a trademark. So you see that Madrid system is not only a filing system, it's a long-term system designed to support your brand globally and support you even at the filing stage. So this time I would like to show you a little bit about eMadrid, our online and centralized management tool. So let me now show you some of that. So with the new eMadrid, you can explore everything in one workbench, giving you a single and centralized secure hub to handle all your Madrid registrations. It allows you to share access and collaborate with your team seamlessly, which is especially valuable for SMEs and big businesses, where several people may be involved in managing renewals and changes or exchanging data. You also receive a real-time updates and prompts on key actions, whether it's whether a renewal is approaching, or a communication from WIPO, or a request needs your attention, eMadrid is very useful. On this screen, you will see how a workbench looks like. So when you go to eMadrid and go to your personal workbench, you will see that you have different filters here where you can identify already. This is just an example of a trademark holder with lots of assets or trademarks. So you can see you have the active registrations, and most importantly, you have the required action. So you do not really need to look at your assets, your trademark one by one and see what needs to be done, what's need my attention. Everything will be highlighted in your workbench. See, for instance, here you can even modify your workbench depending on how you would like your screen to be, or depending on what type of search you're doing. If you can see a cogwheel button here, and press on it, and then you can even see that you can modify even more so that you would be able to, so that eMadrid can serve your purpose. On this slide, I would just like to quickly show you the support, the resources that you can use for your business and for your practice. So we encourage you to explore these tools, especially if you're filing for the first time or planning a broader expansion. As we close, I would like to tie up together what we have heard today. So with Elio and April highlighting the critical pre-filing checks needed in Southeast Asia and China, especially navigating the first-to-file system, strict examination in China, for instance, the classification challenges, the importance of availability searches before filing. Those are some topics or some discussions that we have heard from April and Elio. So the Madrid system helps you take your brand beyond borders more efficiently and more affordably, and with flexibility to grow at your own pace. If you would like to personalize guidance and you would like more information, please book a call or a meeting with us. Thank you, everyone. So we're back here, April and Elio. And this time, we're going to be going to our moderated discussion, where we will be able to also answer some questions from our chat box. April, were you able to answer some of the questions already?
Yes, sure. We can start from the first one, I think. The first one is cheap as trademark database open resources? Yes, it is. I have shared in the chat box. And the second one, due to the competitive and first file nature of trademark registration in China, how early should SMEs file, especially if they have not yet entered in the Chinese market? Would you recommend filing before market entry or product launch? The first one, how early? As early as possible, absolutely. Ideally, immediately after finalizing your brand name and before any public disclosure. I will say maybe it's the right time. Would you recommend? I will recommend filing before market entry. Because
definitely,
sorry?
I would agree with you, April. Just because with the with the technologies these days, your product, if not protected, can easily be seen somewhere else in some other parts of the world. And if it's not protected, something can get terribly wrong at the very first stage.
Yes, absolutely. Yes. if you delay any product launch or exhibition attendance, you risk losing your brand to squatters who can legally block your market access, I will say, and prevent you from listing on major e-commerce platform like Tmall or Taobao or Jingdong platforms. So making early registration is the low cost and high impact insurance. And the next question, can you send a copy of webinar's presentation? I think we could, right?
Yes, I think this is what we're going to do at the end of our webinar.
Yeah. And next one is how are first filing issues subsequently regulated? Where are objections considered in the courts or the appeals council in CHIPA? It's a little bit complicated in China because in China, disputes regarding the first to file principle follow a mandatory administrative first judicial final process. It means that objections are initially adjudicated exclusively within the CHIPA by its review and adjudication department. Not directly in court. If an applicant disagree with a refusal or an opposition ruling issued by the internal department, they must then file an administrative lawsuit with in Beijing Intellectual Property Court because CHIPA is based in Beijing. With any further appeals going to the IP Court of the Supreme Court. Therefore, there's no indicate appeals council, and the judicial intervention is the only possible after exhausting the mandatory administrative review within CHIPA. I hope it's clear now.
Thank you, April.
And then, yeah.
Maybe Elio would like to emphasize something because Elio has a very technical presentation, and which is really, really good. There's a lot of information inside. Elio, is there something that you would like to really highlight in the presentation that you have just delivered?
Well, thank you very much, Aileen. Of course, I follow you and April in all your comments and considerations. So I would say that the strategy of protection of trademarks should start in the company at the very beginning when the ideas of a new brand comes up, and so much earlier than let's say the launching of the products, even on the internet. Even before, let's say, requesting the assignment of a website of a domain name. I take this opportunity also to answer the question that is posted in the chat that is related to the electronic signature of power of attorneys. It refers to these countries, so I assume that also Southeast Asian countries are in the ambit of interest of this question. I would say that there is an increasing acceptance of, I would say, electronic signatures of power of attorneys in trademark matters in Southeast Asian countries, in particular in those countries that have a very high level of digitalization and recognition of e-signatures documents, like Singapore, to some extent Malaysia, Indonesia, and Thailand. I would say that I would always perform a cost and benefit, let's say, analysis, because if you have thousands of trademarks, probably you can risk to have to DocuSign or to sign electronically a power of attorney. But if probably you are filing a few trademarks, probably it is worth to use standard methods that can protect you against counterparties' objections, for instance, in a legal proceeding or in a court case. It's always a case-by-case approach. But you can take the risk, and in some countries they are accepted, even though there are some case law against. Probably final comment is that the Madrid system helps a lot on this, because of course you will be requested to sign power of attorneys to local agents only in case of provisional refusal, because in case you file directly through Madrid, at least at the very beginning, you don't need any, let's say, power of attorney, let's say, signed on behalf of, in favor of local IP representative. Thank you very much.
Thank you so much, Elio. And I'm really glad that we have emphasized the importance of the pre-filing strategy. And because that's very important. If you would like to have a successful Madrid filing, your basic mark should be strong. It has to be founded in a strong basic mark for your Madrid application to be successful, because you were talking about provisional refusals. And in some countries, like for instance, you have mentioned Thailand, with a strict examination of list of goods and services standard. And this is true because we've seen a lot of provisional refusals. So if we already know that, when you are designated in Thailand and there will be a provisional refusal related to your list of goods and services, if you do not do your pre-filing check, then of course you will be getting a provisional refusal. So it's really important at the very beginning, check the list of goods and services acceptable to before the Thailand IP office, and then you formulate your list according to that. And in Madrid system, that is not included in my slide. You can also have the option of limitation. For instance, you can have your basic list, which will cover, for instance, clothing in class 25. But then you can have a limitation for Thailand, for instance, where you can develop your list of goods and services, particularly related to and in accordance to the standards of the Thai office.
Yes, indeed, Aileen, I definitely agree with you. I mean, it's a matter of I mean, you can be prepared, and it's a matter of allocation of resources, because if you know that there might be a provisional refusal, you can be prepared to that, because of course there is a discretionary, let's say, evaluation also by examiners sometimes. So I don't want to make SMEs, let's say, illuded that everything goes smoothly. But if you perform this pre-filing, and you, let's say, allocate some resources to responding to provisional refusal, you will always have the best value for money solution compared to national filings, if you use Madrid, I mean.
That's true, Elio. Thank you so much for that complimentary comment. April, is there anything that you would like to add? Because we're already nearing the end of our webinar.
I think maybe I could I did mainland China perspective about electricity signature, because of our different compliance environment. Basically, we accept electricity signature, but you should use the verified platform, not DocSign. It's blocked in China, I will say. Yeah. Thank you.
Okay, so we're at the end of our webinar now, and I would like to thank all the participants. Elio, thank you. Again, this is a very significant webinar. This is the first time that we ever have a webinar together with IP SME Helpdesk. And of course, to our participants, please stay tuned for the next upcoming webinars, because this is just the first part of the series webinar on the regional webinar related to the Madrid system and the Hague system for the next part. Thank you so much, everyone. Thank you.
Thank you.
Thank you so much to all the speakers. Thank you, Benoit, Valérie, April, Elio, and Aileen. Thank you for your presentation. presentations. Very insightful, and I'm sure it was very useful to everyone. We received a final question here. It'll be answered through email later. And thank you again for all of your questions and for the discussions. And stay tuned. There'll be more of this. And hope you all have a great day.
Thank you. Have a nice day. Bye-bye.